And the last possession agreement we're going to go over is the limited access to property possession agreement. And this agreement is used in special circumstances. For example, the buyer needs to store items in the garage, may have appliances that need to be delivered prior to closing. There may be specific work that the buyer needs to do prior to moving in and they want to get started early. The circumstances for all of this will need to be described exactly within this purchase, the access to the property addendum. This is not for the buyer to take physical possession of the property. Again, this is limited access, and you're going to define exactly what that access is pertaining to your particular circumstance in this section in number 1. There is going to be an amount agreed upon, and the seller is going to grant the buyer this limited access from this date and for the sole purpose of exactly what the terms of the access are. Typically, the seller is still going to be living in the property. Utilities would remain in the seller's name. And if the seller is remaining in the property and the buyer wants access, there should be some notice given. The buyer should not just come and go at will. Okay. Liability, seller is not responsible for, and the buyer waives and releases the seller from and against any and all claims for damages or loss to the property or injury to person suffered by the buyer or anyone associated with the buyer with regards to this access. The buyer acknowledges that the buyer should consult an insurance agent and an attorney to obtain desirable insurance coverage, and an attorney to make sure that they understand the risks. Okay. Again, if the buyer defaults, buyer either needs to restore the property, remove whatever they've stored, and release it. Okay. Any default under the agreement shall be a default under this addendum, just like it was on the others. If the seller defaults, then the seller is going to be liable to pay the buyer for any actual costs. Okay. And like we talked about utilities, the seller typically is still in the property, so the buyer shall not be responsible for all the utilities. Buyer shall not cause any permit or any liens of any kind to be placed against the property during this agreement, and then everybody signs it. So this document is used very rarely, and both parties need to be aware of the risks. Buyer changes anything and they default, they'll be responsible for returning it. If the seller defaults, they'll be liable to the buyer for the cost of anything done on the property under the agreement. And then again, if the buyer stores personal property, they need to acquire the proper insurance to cover the items, because the seller is not responsible for any damage that may occur. All of the possession agreements contain a level of risk for each party. All the parties need to weigh the risks carefully and seek legal counsel if there are any questions, concerns, or if issues arise. As with all of the documents we go over, especially these special ones that are additions that are not normal parts of the contract, make sure you seek legal counsel. If you have questions, go to the mentors, come to me, and we will get things figured out and help you get things put together for your clients.